Welcome everyone. Today I'm going to discuss about the intellectual property in the new economy, and this is one of the important aspects right now because as an entrepreneur, as an inventor, as a creator, you need to be very much focused on that particular point. What is the intellectual property? You have patent, you have copyright, you have trademarks, you have trade secret, many of the things you have. So what is patent? An intellectual property right granted by the government to an invention that gives him or her the exclusive right to the inventions for up to 20 years in exchange for disclosing the details of the new technology to society for its ultimate benefit. Copyright, an intellectual property right granted by a government, the author of an original literary, dynamics, musical artist, or other eligible creative work. What is trademark? An intellectual property right granted by a government to an individual, business, or legal entity that creates or uses its distinctive words, names, symbols, or devices to distinguish its product or service from those from any other entity in the marketplace. Trade secret, a law that requires that the intellectual property to be protected, not publicly disclosed. The history of patent. Greece, Europe, early patent system reinforced wealth of elites. What is the rationale for issuing a patent? The founding father designed a patent system that would stimulate the inventing genius and entrepreneurial energy of the common man. So there is a two things. One is bargaining theory, another one is natural right theory. Two goals of today's US patent system: stimulate invention, property rights are protected to help ensure creations and productivity, share knowledge, promote progress, and the general welfare by disclosing invention. How did the US create a patent system for everyone? Simple application procedure, low fees, no working requirement, disclose of a new technology, examination system, new technology marketplace. These are the inventions. So there are one thing that faster of innovations, 20k in 1880s, then 40k 19s, 100k in 1980s, in 2040s 300k, and it's actually increased the increase. What exactly can you patent? The Patent Act, a mechanical manufacturer process or compositions of the matter can be patented if it demonstrates the following three characters: novelty, non-obviousness, and utility. Creation for patenting. Novelty. Machine, manufacturing process, or compositions of matter must not have been previously described or known. Utility. An invention must function as intended. Non-obviousness. A patent requirement that ensures that the idea is new. Two categories for patent invention. One is products, another one is process. Product, physical thing, manufacture, composition of matters. It defined as a means to an end, a means of doing business now, or a new way of doing something old. Non-obviousness hurdle, camera plus phone equals to non-obviousness. Plant and design pattern, distinctive and ornamentally. Applying for a patent, determine type of patent, determine filing status, decide to fill a provisional or non-provisional patent applications. So enforcing patent right, it is up the patents to enforce their patent against infringer by the filing a race in the federal court. Patent holder have the legal right to exclude other from making, using, selling, or importing the inventions. Patent infringements, demand the infringer stop or pay damage for the past infringement, offer a royalty, ignore the infringements, or postpone action, file a patent infringement lawsuit in federal. Litigation versus licensing. If the objective is to stop a compare from the offering a product that infringed one patent. If the objective is to obtain royalty for the use of one's inventions. Should you take your claim of court? To enforce a patent through litigations, you must determine the who, what, where, when, and how of events, like determine who infringes. Create a claim chart detailing the product or service that has infringed. Determine your location of suit. File your claim as soon as you have proof. Select a judge or jury. Rise of patent asserting entities. Patent asserting entities are companies that buys and license patent in responsible business negotiation that provide legitimate benefit. Patent trolls drive settlement revenue from defendants who are willing to settle in instead of defendant against a suit, acquire questionable patent and file suit against multiple defendants, really rely on the threat of litigations expenses to extract settlements. Under the American Invent Act, third parties can align patents and, if evidence so warrants, have their claim invalidated by the USPTO's Patent Trial and Appeal Board. So, alternative to legitimate litigations are costly, timely, and disruptive. Alternative disputed resolutions include meditations and arbitrations. What is meditation? Meditation is actually an informal type of dispute resolution in which a third party helps two parties come to an agreement. What is arbitration? A process in which the parties to a dispute present arguments and evidence to a dispute resolution practitioners who makes a determinations. So the value of IP of to a national economic survival: 38% US GDP, 80% market value. So to learn more about IP visits, we can go for the intellectual property owner education foundations, and this way we can grow and understand different kind of innovative things, and we can grow our economy in a sustainable way. So there are many interesting points we can decide, many interesting aspect we can decide, many interesting fact we can decide. So beside that, if we can focused on one of the patent presentations, that how actually patent work. So that time we can share different kind of interesting aspects of the society, we can share different kind of valuable things of the society, and most important thing is that we can understand the introductions of the patent and their appeal. Let's see what is actually patent. A legal protection who is given invention right to exclude other from performing certain activity in country to issue. So which means sanctioned monopoly for a set number of years in exchange for disclosure to the public, does not give the inventors the right to make, use, or sell the patent invention. So, why patent and invention? Source of recognitions for the inventors, incentive to develop a commercial product, license to an existing company, startup a new company, protection against limitations. So what we can do for the patents? So novel, not previously known or used by other, useful, have a known use of product, a concrete or legible result, non-obvious, it is obvious to Poshita, cannot be found in a single or reasonable combinations of pattern that would yield a predictable result, idea, law of nature, and science principle. See, 1719 first US Patent Act entitled an act of promote the progress of useful act. 1850 introductions of the concept that an invention must be non-obvious as well as new and useful. 1978 patent cooperations treatly put into effect allow single worldwide filling. 1980 Bay and Doles Act deliver written title to result of federal funded research. So there is a most important factor is publications versus patent. Scholarly publication, authorships somewhat negotiable, must have done the works, effort paramount, features idea can interface with subsequent patentables, only directive comparable result can be lead to lose in the priority. Patent. Inventorships a matter of law, constructive reductions to practice encouraged, conceptions paramount, disclosure of idea for and many future uses as possible is strengthen the pattern, result from analogics system can result in prior art and obviousness rejections. Abstracts, what are the patent of a patent? Abstract, background of the invention, summary of the invention, figure with brief description, detailed description or specification, fully description what the invention is, how it is made, how it can be used, claim set of legal boundaries of protection, independent and dependent. Three different type of patents: utility patents, plant patents, and design patents. These are the major things. How does one obtain a patent? First, assessment for whether or not the invention is patents. File a provisional application. Internationals non-binding examination and allow an applications to postpone the applications. US utility applications examine rounds and appeal require more time and money. Total average cost of a US patents. Total average time to obtain a US patents. So BC approach to obtain a patent, we can go for the disclosure. What is disclosure? Disclosure is a ideally when you can describe both what the invention is and what is accomplished. Evaluation: can these inventions be patents? Is there any prior art? Is this invention new, useful, and non-obvious? Is it the ought-ful to patent this invention? What product could come from these patents? Is there any market for said productions? Provisional applications: preserve worldwide right against initial disclosure, given you 1 year to be decided whether or not to pursue patent. Initial publication: if you publish prior to filing a provisional application, you lose the right to file intentionally. Patent cooperation: treat an international application which claim priority to provisional US application and have priority protection for up to 111 countries. Non-confidential disclosure is graded and summarize the technology as well as the unmet need or opportunity. During this phase, more marketing and search for license should be completed. Is there is no market or the market is too narrow, then the application may not be pursued past the night. After the re-evaluation, there may be additional publication with interested animal data protection and further commercializations. So conditions of marketing or finding a license as well as additional publications. National stage application with expensive examination round. Rely get this far in the patent process with a license. So these are the some important overview of the pathway to commercializations. Besides that, there are some of the specific things happening US patent issues with the data and other things. So if you observe these things in 2000, actually royalty income of the US academies actually increase, and this is the get rate US for more than $94 million royalty since 1970s. And Google and Stanford could earn more than $200 million depending on how stock perform. And Remittance and NYC 650 million deals will royalty pharma make. Boston College. This is the some of the Sarah College, Solasta and GMS Energies and many more things actually take a very good advantage of these patents and other things. So if we can do the proper patents and other things in a professional way, this way we can grow our business and we can grow our effectiveness in an effective way. So that's why I request all of the business organization, you have to understand your patents, you have to understand your patents and other things in an effective way. And most important factor is that the present world, the copyright patent and these things is increasing because of lot of invention, because of lot of innovations around the world happening. And most important thing is that if we can invent properly and if we go for the copyright patent and this kind of things, it will help us to grow our economy in an effective way. And most important fact is that if we can grow our economy in an effective way, that time we can utilize the fact, that time we can go for the proper channels and other things. So if you have any kind of questions, you can ask me, and if you have any kind of specific question you want to ask me, you can. And most important factor is that we are very much open to collaborate and give you the proper learnings about different interesting points. Thank you everyone. If you have any questions, you can directly communicate. Thank you.